हेलो फ्रेंड्स। इस वीडियो में हम डिस्कस करेंगे एक कॉमन इशू है कि जब भी हम मटेरियल मूव करते हैं फ्रॉम वन स्टेट टू अनदर स्टेट और समटाइम्स विद इन द स्टेट। फॉर एग्जांपल, यू आर मूविंग मटेरियल फ्रॉम दिल्ली टू अ प्लेस इन समवेयर इन महाराष्ट्र, or suppose you are moving material from one of the port in Gujarat to the Delhi or to Haryana, etc. And in the meantime, in the transit, your goods is intercepted by the GST department, the mobile squads and the officers of the enforcement department, and they levy a penalty of 200% of the tax. 200% ऑफिसर्स पेनल्टी लगाते हैं अगर उनको डॉक्यूमेंट्स में कुछ इशू लगता है, एंड समटाइम्स दे लेवी पेनल्टी, दिस हार्श पेनल्टी आई कैन से, इवन ऑन द क्लरिकल एरर्स लाइक एड्रेस में कुछ प्रॉब्लम है, ई वे बिल थोड़ा सा एक्सपायर हो गया है, सप्लायर के एड्रेस में प्रॉब्लम है, रेसिपिएंट के एड्रेस में प्रॉब्लम है, so on and so forth. There are many reasons they are levying penalty of 200% tax under section 129(3) of the GST Act. ये वीडियो हम क्यों शूट कर रहे हैं, क्यों बना रहे हैं, उसका ऑब्जेक्टिव है, अभी रिसेंटली ऑनरेबल सुप्रीम कोर्ट ने एक बड़ा pragmatic or you can say very beautiful judgment has been delivered by honorable Supreme Court in the case of ASP Traders versus State of Uttar Pradesh. And this judgment has been authored by one of the most, you can say, one of the best judge of the tax, Justice Padiwala, with Justice R.R. Mahadevan, and one of the beautiful judgment you can say on section 129. And Justice Padiwala has categorically stated and expressed his view कि जब भी आपकी गाड़ी पकड़ी जाती है और आप कमर्शियल एक्सीजेंसीज की वजह से, आपके व्यापार की जो प्रॉब्लम्स हैं, आपके कस्टमर को माल चाहिए, अभी माल आपको छुड़ाना पड़ेगा, आप 200% जमा करके MOV 5 में अपना गुड्स रिलीज करा लेते हैं, व्हीकल रिलीज करा लेते हैं, क्योंकि आपको अपने कस्टमर को माल देना है। आप उस वक्त इतनी जल्दी में होते हैं कि कई बार आप बोलते हैं कि मटेरियल रिलीज कर दीजिए, मैं पेनल्टी पे करता हूं, और समटाइम्स व्हाट GST डिपार्टमेंट presses is they do not issue the proper GST order in MOV 09. So this judgment is basically revolving around the issuance of MOV 09 when we make the payment in form DRC 03 and vehicle is released or goods are the released. इस पर्टिकुलर केस में ऑनरेबल इलाहाबाद हाई कोर्ट ने ये व्यू लिया कि सेक्शन 129(5) सेज कि अगर आप पेमेंट करते हैं पेनल्टी की 200% ऑफ द टैक्स, अगर आप DRC 03 से पे करते हैं तो ऑल द प्रोसीडिंग्स स्टैंड्स कंक्लूडेड. When you make the payment of 200% of the tax, the 129(5) says that all the proceedings shall gets concluded, and they opined that after the conclusion of the proceeding, the officer is not required to issue a detailed speaking order along with its summary in DRC 07 plus MOV 09. So Honorable Supreme Court categorically stated that this is not a correct law decided by Honorable Allahabad High Court in the case of this ASP Traders. The officer is duty bound as per statute to issue a reasoned order. They are required to pass a detailed speaking reasoned order so that the affected party can file an appeal before the appellate authority. This is not the mandate of section 129(5). Honorable Supreme Court says 129(5) can be applied when the party expressly says that they don't want to litigate it further and they want to close the proceedings. In that case only this view can be taken, but in otherwise they are duty bound to issue the form MOV 09 in under section 129(5). So what is the suggestion to most of the traders? Whenever your vehicle is intercepted by the GST department in transit, don't get panic over there. And suppose due to the commercial exigencies you have to pay that 200% of tax, pay that amount under protest. Write a letter to the officer that I am depositing this 200% of the tax under protest due to my commercial exigencies, due to my requirement of my customer. This payment cannot be construed as a admission of the GST liability. Very, very important. You have to write a letter to the officer that this payment of 200% of the tax cannot be construed as an admission of my GST liabilities, and this is I'm depositing under protest. In that case, you can file appeal before the appellate authority and you can argue the matter on merits. Sometimes the proceedings are quashed by the first appellate authority or by the Honorable Jurisdictional High Court also. So this point you have to remember, you have to give the consideration that the protest letter has to be there. It is a must requirement, mandatory requirement. Otherwise 129(5) may create a problem, but now the Honorable Supreme Court is very clear that order has to be issued by the officer. So friends, this was a very, very important and pragmatic judgment of Honorable Supreme Court. You can refer this judgment. The SLP number was, the civil appeal number was 9764 of 2025, and it has been decided in favor of the taxpayer and against the revenue. Thank you very much.